As we watch, we are alongside our CBS 2 legal analyst, Irv Miller, who's been watching this content with us this afternoon. And Irv, I want to start for people who may have missed it. This was yet another arraignment in similar fashion as the previous ones, checking all the boxes. Pretty typical.
You know, arraignments are always very typical. It's not a substantive part of this, a very procedural type thing that they have to follow certain rules. They did exactly that today.
Right. I want to ask next about a moment in court that stood out to you, something about when the former president sat down at the desk with his lawyers and saw something that you think he didn't like.
You know, there's always paperwork that the defendant has to sign during these proceedings, and typically it's what are the conditions of his bond. And apparently, from my perspective, there was something in there that he didn't like, and he had, what I heard was a heated conversation with one of his lawyers. So there must have been some condition in there that he didn't want to agree to.
So we have 3 cases right now. We're waiting to see what happens in Georgia. How's all this going to be scheduled and played out?
You know, I wouldn't be surprised if the judges that were involved in this in the 3 separate places actually had a conference call.
So they can talk and
they can talk.
Okay.
You can't talk about substantive things.
Sure.
You can't have ex-parte conversations, but scheduling is one of those things that you can discuss with other judges and lawyers among themselves, and even defendants.
And it's not only judges, it's the attorneys, whatever else is on their plate. It's a whole mountain they have to scale. And
it's not going to go away quickly. I know the prosecutor said that he wanted a speedy trial, but a speedy trial is a defendant's right, not a prosecutor's right. So when they say speedy, you have to really think about what that word really means.
Do the judges in these cases have to negotiate? Do they say, okay, we think this case is more important, or is it just about the timetable?
It's just a timetable right now as to which is going to go first. Some are more complicated than others. One's a state case, 2 are federal cases. I'm sure they think that the case today is the most important, and they'll try to push this one because, frankly, it's easier than the document case. So, and definitely the New York State case, the feds aren't really worried about.
We understand he'll be back in court. I believe it's the 28th, the end of this month. Do we expect to start getting some scheduling information then, or what's the next step?
And he doesn't even have to appear on that date. Okay. All these next dates are going to be status dates. Did they turn over the proper documents? Hey, they're hiding a document, so the judge has to get involved in that. Any disputes about what is going on with respect to the conditions of bond that he has to obey, if he's saying things out of order that he shouldn't be saying, those will be addressed, technicalities. Substantively, the trial will be way down the road, probably 10 continuances from now.
That's what I was going to ask you. Is there any idea how long this could all take?
You have a coin? We could flip it right here. That's how this process works.
Wow.
Years?
I think it's going to be after the election.
Okay. To even get it on the calendar?
No, to have it scheduled,
scheduled
after the election. I don't think they're going to schedule a trial before the election.
Okay.
All right. CBS 2 legal analyst Irv Miller, thanks so much.
Thank you, as always, Irv.
We will have much more ahead on the historic Trump arraignment coming up on the CBS Evening News with Nora O'Donnell.